because it's not something we can initiate because it's outside of our mandate.
True.
But if complaints are brought to us, we can refer you to the relevant authorities with supporting information to say, actually, this complaint is correct and has merit because this is the actual situation.
All right. So we you touched briefly about the issue of dissolution and how, in context, the whole act does not represent the actual practices practiced by people who are practicing cultural customary law. I had an instance an encounter where this person was married in terms of customary law. Then she said they got separated with her husband. So she's moving on. She wants to enter into a new relationship. So I asked, I said, what do you mean you are divorced? I never asked you about this, but today I'm asking. You told me you were divorced. Where did you get divorced? She says, we just went to the pastor, they brought the families, and then they agreed in Jesus' name they are dissolving the marriage. I said, how? Aibu. That can't be. So she says, what do you mean? I mean, we never went to register the marriage. I said to her, that's not how it works. Customary marriage, whether registered or not, you still have to obtain a divorce order. Then I printed out the Recognition of Customary Marriages Act to say, Haibu, look, read. You still have to get a court order to dissolve your marriage. So, talk to us more about that.
Okay, I'll firstly start by saying this. People need to understand that in terms of the Recognition of Customary Marriages Act, a marriage between a man and a woman, one man and one woman, is a marriage in community of property unless the parties have agreed to an antenuptial contract and they have lodged it with Home Affairs before they sign their marriage. Any marriage that is between a man and more than one woman is a marriage out of community of property. And in terms of this piece of legislation, they need to record and sign an agreement between them about what the property arrangement is and who owns what and to what percentage and whether it's bargaining this antenuptial remind me, Isaac, remind me.
The antenuptial contract, or which part of it? Which part of the antenuptial?
When an antenuptial contract, whether it's the accrual or without accrual.
Yes.
That aspect needs to be done. So now, the Act says that whether or not a marriage has been registered does not affect its validity. But it still requires that the dissolution of that marriage needs to go through the court process that a civil marriage would go through in order to obtain a decree of divorce. Now, the people who primarily enter into customary marriages are in rural communities.
Yeah.
They don't have the economic resources to access lawyers like you who will go and represent them in court to obtain this divorce decree. Now, in previous times, there was never this issue of people needing to go to court in order to obtain the divorce decree. The situation, and which is currently happening, is that the same people who negotiated the marriage would be the same people who would be called when the spouses have decided that they can no longer continue with the marriage. The parties from both families who negotiated the marriage will try and intervene and mediate between the spouses before it is then agreed to that it's not happening. The marriage is over. In some family situations, the bride price, magadi, lobola, is returned to signify that the marriage has indeed ended. And that is where there is an agreement about the custody of children and what's going to happen in that situation. In other families, it is not required of the bride price, the lobola magadi, to be returned. It suffices that an agreement has been reached, it is recorded by parties of both families, and then the marriage is over. So this shows you that there is a gap between what the Act provides and what is done in practice. So there is no trickle of information from the Act and its provisions to the communities and the practices in which these parties enter and practice within rural communities.
When
So that is the biggest problem. So your friend or the situation that you have just spoken about is not the first, and it is unlikely to be the last, because people are not aware of what is required of them in terms of this act, because they are not even aware of the act itself and its provisions.
True. I mean, what you say is important. They're not even aware of the existence of the act. So obviously, the walkabouts, the act, they will not be able to understand. In the beginning, when we started the interview, you spoke about how two ways you may be championing African customary law, but you also champion women's rights. And I particularly understand why they need to go to a court of law. Firstly, the marriage in terms of customary law is in community of property. And in community of property is just issues around assets and creditors, most importantly. And I think here they're looking at creditors in terms of liability. To say at the end of the day, there are people who have an interest in that joint estate. That is why you need to have a piece of paper from a court of law saying you have divided the what used to be an indivisible estate. Secondly, I hear things that in terms of children, in most instances where, especially in the rural areas where you find that the man has money and influence, they tend to take those children away from the women or from the mothers. And because you have to go to the court of law, if children are involved, you have to then, the court will then have to solicit the services of a family advocate. So yes, to some extent, there's a huge departure from what is practiced. But you and I have established that the practice seemed to be disadvantageous on the side of women, and that's why codification is to the advancement of women's right. So it's I don't know if it's a win-win.
Well, it's hard to say. It's hard to say, because the only way we can say for sure it's a win-win situation is if we have seen women in rural communities being empowered through this piece of legislation and their rights being protected and asserted. And I am not aware of a research that has been done to ascertain this, because a research project that I was involved with was looking at, firstly, the understanding of the RCMA by officials of the department that is mandated to address these issues. And if that aspect is then not dealt with, then already it's a problem, because it means when these marriages are going to be registered, if the official who is meant to register this marriage in terms of a system of law that they do not understand relating to this piece of legislation, then we already have a problem.
Yeah.
But the biggest problem is the lack of knowledge. By the women, this piece of legislation was meant to protect.
So we have established two things, and I think that needs work on. Firstly, that people don't know the existence of this legislation, that we need a way to get it out there for them to know and read about it. The second thing we've established is that we have no idea if people have benefited from the existence of such a legislation. So there's a need to find out if people... I did say that currently people are benefiting from the act who fight for deceased as bodies in the high courts.
But those are people who have access to funds.
True. So you see...
Funds which will allow them to have a lawyer that can go to court and represent them. What happens now in the situation where a person does not have access to funds that can give them access to a lawyer? So it means that the piece of legislation that is meant to protect them places them at a disadvantage, because it requires of them to go to a court of law which they cannot access because of their economic situation.
True. And, some of them may go to legal aid for assistance. I was dealing with a matter where the couple, the marriage is not registered. They don't use the same surname. And they, most people, when you go and you lodge a divorce, the original court would say, because people write letters these days, like a notice of intention to marry. Because it's some of the developments that people are doing. I see notice and then the response comes with how much the lobola is.
But that's not a new thing. That's something that was done in the past, and it's some of the documents that people can still use to go and register their customary marriages at Home Affairs.
True.
Because it proves the negotiation part of it, that forms part of the entering into and celebrating in terms of customary law as the legislation provides. So it's not a new thing.
So I see it, but if some people don't have any of that, but they themselves agree that they were married. So there's no contention of whether marriage existed. And I'm thinking to myself, if these people didn't have a lawyer, then they would have this man would have probably kicked her out and said, no, we're not married to you and I. Go. The woman, if does not work and does not have information, then right there she thinks, that's it, we're divorced because he kicked me out or I kicked him out.
No, of course. And it's a huge challenge also because many of our court officials are not well versed in the field of customary law. And it is also one of the fields that are under-researched in South Africa, meaning that the evidence that can be produced by people, either in the form of articles or theses or books, is very limited. So it means that it is only people who have the funds to access lawyers, who can access researchers, who will take these matters to court. I'll give you an example of the issue of Oirapale Namani, right? The Children's Act does not deal with customary law adoption of children. Surprisingly, in a country where the majority of citizens are people who live in rural communities and take part in these kind of practices. Now, in the negotiation process, they want to know from the prospective husband, and the bride price, including and once that customary law adoption has taken place, then that prospective husband assumes all parental responsibility over that child. But because the Children's Act is quiet on that, in the event where there is a divorce that needs to take place and maintenance needs to be paid with respect to this child, that husband can refuse and say that that child is not his biologically, therefore he is not obligated to maintain that child. There is a case that was taken to the High Court here in Johannesburg. But the only reason that case is relevant case law is because the people who were involved in this were high-profile people, meaning that they had access to the funds and the lawyers and the researchers who could give them that information to back up their case. What happens and needs that maintenance? What must be done about that?
I'm quiet.
So are you seeing?
Yes.
Are you seeing how it's a problem regarding to the people that these pieces of legislation are meant to protect, but because of the issues of access, then their rights are not asserted, their rights are not protected?
I'm quiet because what you're talking about is what I dealt with just 2 weeks ago. Not far, where we rapile money, and then when they divorce, lady wants maintenance. He says, I didn't legally adopt this child. And he says in his pleadings, I culturally adopted the child. Now, that does not count as an actual adoption. So, I think...
No. In terms of this, maybe I will send you the case. It does count as adoption.
No, it's just that I get it. But then the lady said, because you don't want, out of principle, it's fine. But she didn't want to pursue it further. She just felt because of principle... On principle, it's fine. I'll take your pleading, and I don't want anything from you. Let's just get this one over. What I'm trying to say is, I understand correctly that the law, the paper RCM or RMC does not recognize that cultural part of adoption. It's missing. It needs to address it, and I'm glad you're making me aware of it.
No, definitely. It's both the RCMA, but it's also the Children's Act that is silent on this, especially in issues where the best interests of children are supposed to be upheld. And where do these majority of children in South Africa reside? In rural communities. Under which system of law do they live? Customary law.
Kagiso.
Now, customary law as a system in the rural community, the tribal courts are able to effect this maintenance. The problem comes in when these matters are then escalated to your regional magistrates and high courts by people who have access to the funds. So whoever is at a disadvantage is often the women and the children who cannot defend themselves because they do not have access to Kagiso and Isaac, who can go and argue their case for them.